Okay, we're going to get started with our first panel. And it's my pleasure to moderate this panel on enhancing access to justice for families through new lawyering models. And on this panel, you're going to hear from people who are actually implementing some of the innovative models that we've researched and talked about. And because these panelists are implementing recommendations that we made in our book, I thought it might be useful to start with a short summary of the book Jana Singer and I have written. It's called Divorce from Reality, Rethinking Family Dispute Resolution. And in this book, we take a look at some of the dramatic changes in the processes surrounding family dispute resolution over the last 30 years. I'm sure many of you are familiar with them. We begin with a review of the critique of the adversary system that really took hold in the 90s. As many of you know, critics of the adversary system argued that it was backward-looking, too win-lose. It was an approach that exacerbated and prolonged parental conflict. They also argued that it did little to teach parents how to manage that conflict and how to work with each other after the conflict was over. So all of this harmed children and undermined family law's principal goal, which is to foster the best interests of the children. What we call the paradigm shift in family dispute resolution was a response to this critique. It replaced the law-oriented and judge-focused model with a more collaborative and interdisciplinary regime that de-emphasizes legal norms and encourages parties to take a greater role in resolving their disputes. It uses new processes and tools like mediation, parent education, parenting plans, and new personnel like mediators, parenting coordinators, and custody evaluators to resolve conflicts in families. So the book looks at this new regime and asks whether it responds to the needs of 21st century families. And our answer is a qualified no. While it may be an improvement over the adversary system, the new regime is built largely around divorcing nuclear families, a model that fits poorly with the more complicated realities of today's disputing families, who include, among others, many non-marital families. The new paradigm also largely fails to acknowledge that some parents and children need the protection afforded by traditional legal processes and authoritative decision-making, something Melinda referred to. We also find that the legal profession has been slow to respond, both to the skills needed to operate in this new regime and to the virtual disappearance of lawyers in family court. As a result, the majority of today's disputing families must navigate a complicated and tiered system without access to legal advice. And we, of course, believe this jeopardizes durable and just results for many families, particularly low-income families. So we made a number of recommendations in our book, including moving some disputes out of court, developing new models of delivering legal services, and new approaches to legal education to train future lawyers in this new regime, which brings me to our panel. The panel bios are in your packet, so I won't give an extensive introduction of each presentation. But I will give a short one before each presentation. So I'm going to start with Suzy Eckstein to my right, who's a partner with the law firm of Oakley and Eckstein in Montgomery County, Maryland. She's been one of the leaders in the collaborative practice movement in DC and Maryland, and has also been involved in a project to extend collaborative practice to low-income families, which has been particularly, I was just telling her, a wonderful experience for the students in my clinic. So she'll talk about that this morning, and we'll start with Melinda. Each speaker is going to speak about 10 minutes, and then we'll have a lot of time for discussion. Thank you.
Good morning. So I just wanted to sort of first get a sense of who's in the room, although I do know a lot of you. How many of you have been trained in the collaborative process? Okay, looks like close to half. How many who have not been trained have attended some kind of informational session? Okay, good amount of you, great. So I'm going to tell you a little bit about what collaborative is this morning. And for those of you who have already been trained or have gone to an informational session, I think you'll find it helpful because it is often hard to figure out how to boil down, which I only have 10 minutes to do, what collaborative is, and explain it to somebody, a client or somebody else in the public. So I'm going to sort of give you a way to do that, and then talk about the differences of other processes, and then let you know sort of what's happening in the world of collaborative, including in the helping low-income families. But I wanted to start, I don't have a video of clients, but I do have an email that I received from a client, and it just sort of embodies why I'm so passionate about this process, and hopefully you'll want to learn more about it when you hear what it did for this family. This is from my client who's given me permission to read it, although I've changed the names and some of the information just so you can't see who she is. As I received the judgment of absolute divorce today, I can't help but recollect that day a long time ago when I first met you. I was a sobbing mess. I have such a clear recollection of that moment when you said, there is a different way to do this, and explained that with a collaborative divorce, the children will be spared arbitrary professionals making arbitrary decisions about their lives. The children will come first in every and all decisions we make. I remember thinking, she says I can do this, but there's no way in bloody hell collaborative will work. Thank you for your hard work and patience and everything else that it took to get us to the end of this arduous, impossible process. We achieved the impossible because my husband and I did collaborate on every single, in caps, decision. And in the end, the children are benefiting. The children were put first in every decision, and there is nothing better that can be said about the whole mess. And I'll tell you at the end the postscript to this family a couple years later. So what is collaborative? Collaborative is, this is the elevator speech, so get ready, is an out-of-court settlement process where the parties and professionals work together to find solutions that make sense for the parties and children. It is efficient, private, and cost-effective. It's a very supportive process in that each party has a collaboratively trained attorney by their side throughout the process. They also have the option of calling on financial professionals and mental health professionals for additional support. So sometimes when I give that speech, people are like, well, how is that different from mediation? I mean, we talk, in mediation, people look at other professionals sometimes and bring them in to help. So there really are four main differences of the collaborative process from mediation and really any other process. The first one is the first thing I said, which is the parties agree and the professionals agree upfront and actually in writing that they're going to do what makes sense for everybody involved, including their children. You don't do that in any other process. In mediation, you come and you want to come to an agreement and you work to do that, but you don't sign a commitment to do what makes sense for the other person as well as yourself and your children. The second thing is that there's an affirmative obligation to disclose in the process any information the other person would need in order to make good decisions going forward. So while in other processes you can ask questions and hopefully get the answers, in this process, if my client knows and hasn't been asked the question, there's something important for the other person to know, it's our duty to give that information voluntarily. The third thing is collaborative is for settlement only. So there's to be no threats of, well, forget it, I'm just going to court. Now, does that ever happen? Of course it does. People get upset, but the commitment they make not to do that brings them back to the table. And the final piece is that if for some reason you can't settle the case within the collaborative process, the professionals who are involved, including the attorneys, cannot be part of the litigation process. And the purpose of that is really to create that safe container where everybody is just focusing on settlement only. They have their full attention on the settlement process. So when I talk about other professionals involved, people usually say, well, that sounds really expensive. Like, how can people do that? It'd be great to have all that support and have a center where they can get a sliding income, but how can people do that? Well, this is the way I think about it, and this is the way, to me, it truly works. It certainly works in my practice, is there's a pie of things that need to be done when families are transitioning. And that pie can be, and traditionally was, handled by the lawyers, sort of talking to other people on the side. In collaborative, what we do is we carve up that pie, and we give pieces to the people who can do the pieces best. So financial neutrals, helping people with budgeting and figuring out what their assets and in a lot of cases these days, what their debts are and how to manage them. And then the mental health professionals who can help the parties deal with their emotions to be efficient in the process and also help them with their parenting plans. And often those folks are less expensive than the attorneys. I think one of the most important benefits, and Melinda talked about this a little, is bringing in the voice of the child. So in the collaborative process, one of the mental health professionals will take on the role of a child specialist. And what they do is they will talk to the children and bring their voice into the parenting sessions where the parents are working with the mental health professionals to figure out their parenting plan so that the voice of the child is heard. So I'd love to tell you more about how that works, but I don't have time. So now I'm going to tell you about sort of what's happening in the world of collaborative practice and the growth. So there's an International Academy of Collaborative Professionals. And that International Academy of Collaborative Professionals has members now from over 24 countries. So they recently had their forum in Washington, D.C., and I love going to the IACP forum because there was somebody there from Netherlands, Hong Kong, lots of people from Italy, Spain, I mean, just all over the world. And it's so interesting to hear how everybody implements this process that was started by a very unassuming man in the 1990s. His name was Stu Webb, interestingly, in Minnesota. So a lot of good things coming out of Minnesota. Collaborative practice is being taught in many law schools around the country, which Jana and I learned when we were at the IACP conference. We put on a presentation about our class here that we've taught for the last 3 years at University of Maryland for the students' collaborative law and practice. And this year, starting in September, it was being also taught at Harvard Law School. So where have the bulk of efforts in the last few years growth? Something that's really near and dear to my heart, a nonprofit that I'm part of, is called the Collaborative Project of Maryland. Group of practitioners found that thinking about that clients can go and they can get mediation services and support for litigation services if they can't afford to do it otherwise, but they couldn't for the collaborative process. So we wanted to be able to do that for families. So we formed the Collaborative Project of Maryland, and we are supported by a grant, fortunately, from our judiciary, who's been very supportive in providing trainings. One of the things that's happening now, which has really increased the success we have in helping clients and getting cases, is we have a pilot project in the Baltimore City Circuit Courts. And what happens is we're there on the scheduling conference days along with the University of Baltimore Mediation Clinic. And so the court helps sort of sort out what cases would be appropriate for mediation, what cases would be appropriate for collaborative. And we're right there on site to do intake for folks who then get matched up with an attorney within 24 to 72 hours. And as Jane was saying, she had a good experience ending one of the cases where the parties were hugging the lawyers, the other lawyer. So students from University of Baltimore Law School are, through their clinic, are being on these cases, and on the other side of the case is a professional who has a lot of experience in collaborative. So we also are working with the legal service providers in Maryland. They refer cases to us, cases that they don't handle where people are not separated yet or custody modifications. And for cases that they do handle, we can provide support in providing the other professionals. And, providing the other professionals, to help support and or mentoring for new practitioners. With the pilot project, it was so successful over the summer, we have extended it now into the fall. And so I'm just going to quickly, because it's time for me to end, give you the postscript to my client's case. So this couple talked about every issue about their kids inside and out. When the client came to me, she was complaining there were anger management problems, accusations of alcoholism, drug. I thought to myself, I'm not sure if this is a collaborative case. But the clients chose the process, and they worked so hard, they came up with a parenting plan that this is 2 years later when I talked to my client. She said all of their friends are jealous because they have this very detailed parenting plan that they carry around with them and refer to when they have issues. So their other divorced friends don't have that resource. And here's one of the most telling things. All us litigators know that when we go to a child custody hearing, and judges hate this, we drag the poor teachers in, right? And we say, you know, is Johnny dressed well on the days he's with dad? Didn't he forget his homework with mom? In this case, the parties did week to week, and the teachers could not tell the difference of which parent the kids were with. Thank you.